when the popo crosses the line. You're at a suppression hearing. The prosecutor just put a bag of evidence on the table, methamphetamine, found in your car. The officer is on the stand, confident, recounting how he pulled you over, how he extended the stop, how the dog alerted. And your attorney stands up and says 3 words, Rodriguez versus United States. And just like that, the evidence is gone. Not because you're innocent, not because the drugs weren't there, but because the officer crossed a constitutional line, and the Fourth Amendment doesn't care about what he found. It cares about how he found it. Welcome back to avoiding prison. I spent 43 years on the other side of that encounter. I know exactly what officers are looking for. And more importantly, I know exactly what you need to know before it happens to you. The exclusionary rule. What most people don't understand. Now let's talk about something most people have heard of but few actually understand. The exclusionary rule. Here's how it works. The Fourth Amendment says you have the right to be secure against unreasonable searches and seizures. That's the promise. But the enforcement mechanism, the thing that actually gives that right teeth, is this. Evidence obtained through an unconstitutional search or seizure cannot be used against you in court. Period. But here's where it gets real. The exclusionary rule doesn't care about guilt or innocence. It cares about process. An officer can find a kilo of cocaine in your trunk. If he found it by violating the Fourth Amendment, that cocaine might as well be baking soda as far as the court is concerned. It's not coming in. Pattern interrupt. Retention rehook. And I've watched it happen. I've sat in courtrooms and watched judges who know the defendant is guilty, suppress evidence because the officer couldn't stay inside the Constitution. Let me show you exactly what that looks like with 2 cases you need to know. Case 1. Rodriguez versus United States, 2015. Let's start with the case that changed everything. Rodriguez versus United States, 2015, Supreme Court. And this one should be required viewing for every driver in America. Here's what happened. Officer Morgan Struble pulled over Dennis Rodriguez for driving on the shoulder of a Nebraska highway. That's a traffic violation. The stop was legal. Struble checked Rodriguez's license, ran his information, issued a written warning. Mission complete. The traffic stop was over. But here's the thing. Instead of letting Rodriguez go, Struble held him there for another 7 to 8 minutes. Why? He was waiting for a drug dog to arrive. The dog eventually showed up, walked around the car, and alerted. Officers searched the vehicle and found methamphetamine. Rodriguez was charged. Open and shut case, right? No. Rodriguez's attorney filed a motion to suppress. The argument? The traffic stop was over. The officer had no reasonable suspicion of other criminal activity. He extended the detention solely to conduct a drug investigation. And that extension violated the Fourth Amendment. The case went all the way to the Supreme Court. And in a 6-3 decision, the court agreed. Justice Ginsburg wrote the opinion. A seizure justified only by a police-observed traffic violation becomes unlawful if it is prolonged beyond the time reasonably required to complete the mission of issuing a ticket for the violation. Full stop. 7 minutes. That's what cost the government its entire case. The methamphetamine, real physical evidence, was suppressed, excluded, as if it never existed. Now, here's where it gets real for you. If an officer finishes writing your warning and then starts asking unrelated questions, do you have anything illegal in the car? Mind if I search? Without reasonable suspicion, that stop just crossed a line. You don't have to answer. And if they hold you there to fish for more, anything they find may be getting thrown out. Case 2. Arizona versus Gant, 2009. Now let me give you another one. Arizona versus Gant, 2009. And this case is about what happens after the arrest. Rodney Gant was arrested for driving on a suspended license. Officers handcuffed him, placed him in the back of a locked patrol car. He was secured. He could not access his vehicle. Then the officers searched his car. They found cocaine in a jacket on the back seat. Gant was charged with drug possession. Now, for decades, police had been operating under a rule from a 1981 case called New York versus Belton. The assumption was, if you arrest the occupant of a vehicle, you can search the passenger compartment. Automatic. No additional justification needed. But the Supreme Court in Gant said, not so fast. The court ruled 5-4 that police may search a vehicle incident to arrest only in two situations. 1, the arrestee is within reaching distance of the passenger compartment at the time of the search. Or 2, it's reasonable to believe evidence of the crime of arrest might be found in the vehicle. Gant was handcuffed, locked in a patrol car. He wasn't reaching for anything. And the crime of arrest was a suspended license. There's no evidence of a suspended license in the car. The search was unconstitutional. The cocaine was suppressed. Let's lock this in. 2 different cases, 2 different violations, same result. Evidence found, evidence excluded, cases dismissed. The limits. Wren versus United States, 1996. Now, I want to be straight with you, because this channel isn't about giving you false confidence. It's about giving you real knowledge, and there's an important limit you need to understand. The stop itself, the reason you were pulled over, that's hard to challenge. Wren versus United States, 1996. Plainclothes officers in an unmarked car saw a truck stop at a stop sign for an unusually long time, then turn without signaling and speed off. They pulled the vehicle over. Inside, they saw crack cocaine. The defendants argued the stop was pretextual, that the officers used a minor traffic violation as an excuse to investigate drugs, and they were probably right. But the Supreme Court said it doesn't matter. If the officer has probable cause to believe any traffic violation occurred, even a minor one, the stop is constitutional. The officer's subjective motives are irrelevant. This is what you need to understand. An officer can pull you over for a broken taillight and use that as a doorway. The stop itself is legal. But, and this is critical, the stop has limits. The stop has a mission. And when that mission is over, the authority to hold you is over. That's Rodriguez. That's the line. What this means for you, the roadside. So what do you actually do with this information when you're sitting in the driver's seat and an officer is at your window? First, you don't argue Rodriguez on the roadside. You don't say, officer, under the 2015 Supreme Court ruling, you cannot extend this stop. That's not going to help you. You fight this in court, not on the roadside. Second, you pay attention to the clock. After the officer hands you the citation or warning, the stop is effectively over. If they continue to hold you, ask one question. Am I free to go? If the answer is no, ask, am I being detained? These 2 questions establish the record. They create the timeline. If this ends up in a suppression hearing, and it might, your attorney needs to know exactly when the traffic stop ended and the detention began. Third, do not consent to a search, period. If an officer asks, do you mind if I take a look in your vehicle? The answer is, I do not consent to searches. Calm, respectful, clear. Here's why this matters for suppression. If they search anyway without probable cause, reasonable suspicion, or a warrant, and you clearly stated you did not consent, that search is almost certainly illegal, and anything found in it is getting excluded. Don't give it to them voluntarily. Now, before I take you through how a suppression hearing actually works, because knowing the procedure is just as important as knowing the law, let me ask you something. If this information is valuable to you, share this video with one person who needs it. A family member, a friend, someone who drives. Because the gap between knowing your rights and not knowing them, that's the gap between a conviction and walking free. Subscribe to survive the encounter. Your safety and your freedom depend on what you know before the blue lights flash. The suppression hearing, how it actually works. Let's go through it. A suppression hearing is not a trial. It's a separate proceeding. A hearing before the judge, no jury, where your attorney argues that specific evidence should be excluded because it was obtained in violation of your constitutional rights. Here's how the procedure works. Your attorney files a motion to suppress. That motion has to be specific. It has to state exactly what evidence should be suppressed and exactly why. The traffic stop was extended beyond its lawful mission. Rodriguez. The vehicle was searched without a warrant and no exception applied. Gant. The prosecution then has the burden. They have to prove, by a preponderance of the evidence, that the search or seizure was constitutional. Now, here's where it gets real. If the judge grants the motion, if they find the stop or search was unconstitutional, the evidence is excluded, not just from the trial, from everything. It cannot be mentioned. It cannot be referenced. It does not exist for legal purposes. And in many cases, especially drug cases where the evidence is the case, that's the end. The prosecution has nothing left. Charges are dismissed. I've watched this happen. I've watched cases collapse in a suppression hearing because the officer, a good officer maybe, made one mistake, held someone 7 minutes too long, searched a car they shouldn't have, and that mistake cost the entire prosecution. The Constitution doesn't bend for good intentions. Payoff and in closing. So here's what I want you to take away from this. First, the exclusionary rule is real. It's not a technicality. It's the enforcement mechanism of the Fourth Amendment. When it works absolutely. Second, Rodriguez versus United States gave you a bright line rule. When the traffic stop is over, the detention is over. Any extension without reasonable suspicion, no matter how brief, is unconstitutional. Third, you fight this in court, not on the roadside. Your job during the encounter is to be calm, be respectful, ask if you're free to go, and do not consent to searches. Your attorney's job is to file the motion and argue the law. And fourth, none of this matters if you don't know it before the blue lights flash. That's the whole point of this channel. The information you need before you need it. Let's lock this in. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated.
Against unreasonable
I'll see you in the
searches
next
and
one.
seizures
Stay hard
shall not be violated.
and 540.